another edition of Ask Michael Ehline. This is where I teach people the law in an unorthodox manner by using examples that we see in the news, case law briefs, but it's all about exposing the Leviathan and its instrumentalities and taking back your rights. Know the law and mean to keep it well. Come here to learn from an expert to know your right. Make sure to like and subscribe. Make sure to save, because we never know when the thought police are going to take down this channel.
Hey guys, how's it going? I am attorney Michael Ehline, and as you guys know, I am an attorney licensed in California and Texas. Everything that I do on my show should not be construed as legal advice. I talk about general legal principles, and today I'm going to try and wrap up the Lane Myers plea deal that ultimately was not entered into. I think because the judge found that Mr. Myers was incapable of knowingly and voluntarily entering into it because he disagreed with the actual agreement. Hey, what's going on? This is a public service. Good seeing you, bro. So yeah, I'm trying to get these things down, man. I'm just, it's hard. You know, I was doing depositions. I tried to check out your show a little while today too. By the way, great work, man. You're doing a kick-ass job on your channel. And yeah, so the comment that I made about Rule 211H, the first one was mine. The second one, it said Michael Ehline comment 2 or something. That was not me. So I don't know what that was. Maybe it was someone replying to me, but that was not my comment. I've never said anything disparaging about Mr. Walker or his wife, the alleged victim, or anything like that. I really try. I do support Lane. I'm not going to lie. I am biased towards Mr. Myers because I think that he's in the right, despite the fact that he does some things that a lot of lawyers may not like or that judges may not like, but he's pro per, and that's the way it is. So with that being said, I'm going to try. I'm not going to try. I am going to cover as much of your transcript. This is a public service. I'm going to recover as much of your transcript that you created on one of your lives several days ago. It's part 3 of the Lane Myers plea rejection, and I'll get through as much of it as I can, but then I have another right after this at 5 o'clock. If I don't cover it all, I've got to stop again. At 5 o'clock, I promised BZ that I would go over, I guess he's got some whistleblower stuff, and we're going to have an ex-cop who's a whistleblower come on and break down some evidence that BZ Watchdog has uncovered about some improprieties with the Texas Rangers office and some other stuff like that involving his false arrest. So I've got a busy day today, but I'm going to do my damnedest to make it happen. I am trying my best. This is a public service. As you know, I did blow out my back and came down with a pretty bad case of sciatica. So I'm at a standing desk today, doing my best. I've been going to the gym and doing a lot of stretching. And then in between that, taking my son to his judo classes. He's got a tournament coming up on the 8th. So, you know, everybody pray for Gunner that he kicks ass and he at least gets a stalemate. Even if he doesn't get a win, it's showing up that matters. Just showing up to the fight is what matters. Hey, good seeing you, truth be told. Outstanding. So I just started doing these videos in horizontal again, the lives. And definitely I notice a major decline in audience. So definitely doing your live streams in vertical, I mean, sometimes I'll get 1,000 people. And then when I do the live streams in horizontal, maybe 100. So definitely a big difference there. But I'm not doing this stream necessarily to get a bunch of people. It's just that I promised this unique group of people that I would cover Lane's hearing, because there's not a lot of lawyers who really cover it from the pro Lane Myers point of view. It's mainly just people who want to crap on him the same way they treated Chili DeCastro, same kind of crap. It seems like there's almost like the mob is cruel. Even if someone's falsely imprisoned, falsely arrested, they don't care. They're sort of like free Barabbas. If you guys remember the Bible story, free Barabbas, get Jesus, crucify him. That seems to be how it works. I mean, even the people that were falsely imprisoned in the January 6th case and denied adequate legal counsel, you'll hear people, you know, who are brainwashed by PMS, NBC, and the Communist News Network, CNN. Oh, those Jan 6ers, they're terrible. You know, after all they saw was the edited video and nothing else. And they're not even aware that Antifa was there and that Pelosi called off the National Guard. And then it was basically a setup, which we're going to find out later. But we'll move into the Lane Myers show now. and we'll talk a little bit about what's going on with him. Hey, Mark Williams. Well, you get less on horizontal because the vertical feed is fed into the YouTube Shorts feed, and that's the main reason. But I get a lot of complaints from you guys, especially you old codgers like me, that you don't like it in vertical. And so I'm kind of going back and forth, going from vertical to horizontal, because I want to get to young people. I want to teach the younger crowd about natural law, about the Bill of Rights, about John Locke, about the fact that our rights come from the creator and not from the state, that Marxism is bad and that freedom is good. And unfortunately, they like the shorts. And so I spend a lot of time on the shorts feed and doing shorts to try to sort of win them over, as opposed to winning over them, just to let them see what's going on. And as a result, I've gone from an almost 90% male base, over 50, to about a 40% female base and male base of 60%, with an average age of around 25 to 40. So it's helped a lot with me sort of spreading, evangelizing for natural law, freedom, and all the stuff they don't teach you in the Marxist run public school and college system. So I think that it's helpful, but at the same token, you guys have been asking me to go in horizontal, and I've lost guys like Ralph Riley. I know Wasamata doesn't like it as much in vertical, at least that's what I recall. So here I am. I'm in horizontal. So that's my story, and I'm sticking to it. So I can't. No, I'm not able to transition, man. Yeah, you're one of those old people now too. Well, hey, look, I like it better too from a content creator's perspective when I want to do like a regular video or just doing a live stream, because it's easier for me to navigate and see the screen and stuff like that. Whereas the other one's more set up for handhelds. But look, let's face it, guys, younger people use their phones. They don't use their computers. They use their phones. And when you go in the horizontal or the landscape feature, it has this little tiny image on the phone. So I don't know what the answer is, but there's not a way that I've been able to find to do both. So I'm doing my best with what I've got. And yes, it is possible to do two streams at the same time, brother. But then I'm splitting off my audience. I have to do two separate channels, and then StreamYard, that's what I use, isn't going to allow me to do all the effects. I can either do one or the other. I'd have to literally have two different StreamYard accounts and go from one computer to another computer. So it really kind of sucks. So, yeah, but I'm looking at your questions, guys. Well, I'll take a look at Roku. Oh, I see. Yeah, you use Roku. Yeah, and a lot of the older guys, and I'm not saying you're an older guy, but a lot of my older audience, more mature audience, they do that. They hook up their YouTube to their TVs, and they like watching these shows on their TVs. So yeah, it is what it is. But I'm here for you guys today in landscape, and hopefully I can use some of my professional expertise to tell you what I think about what happened. With respect to the Lane Myers plea hearing. We already went through his oral arguments on disqualifying the judge under Rule 10.1 and Rule 10, I believe, under the Arizona revised statutes. And the judge, the other judge that heard that motion, denied it. But one of the things that I want to point out before we get into this next part of the show is that I never heard her say once anything about the fact that the trial judge, I think Metcalf, if I'm mistaken, let me know in the comments. He made it very clear on the record that it was Lane's fault that he wasn't able to file motions and responsive pleadings in a timely fashion because he decided to represent himself pro per. And I thought that was a pretty darn good argument for disqualification. It shows prejudice because it shows that the judge would be biased more in favor of the state bar and licensed attorneys as opposed to a pro se or a pro per litigant, which I feel was wrongly decided, that this judge didn't even appear to consider that on the record, at least orally. She mentioned other things that she felt did not prejudice the judge. And so I felt that was overlooked. Obviously, it's an argument on appeal, but let's face it, guys, judges don't typically disqualify fellow judges, whether it's the Court of Appeal or even the Supreme Court. They're given great deference, and you have to show an abuse of discretion, usually, and the abuse of discretion standard is very, very difficult, a very difficult threshold to reach. So now we're going to get into what a plea deal is. Okay, so typically 95% of cases, criminal cases, sorry, I'm still kind of wiped out from my depo, guys. Just bear with me. Deep breath, Mike. Because I'm burning the candle at both ends, guys. I'm trying to run a law practice and then come and do these shows. So, and forgive me if I talk like I'm still in a deposition, but that's what happens. So typically in a criminal case, 95% of criminal cases result in a plea bargain. And I think that like 99% of federal criminal trials result in a conviction if they go to trial, which is really interesting. So, and this is not a federal case. I'm just throwing out some statistics to show you why a litigant, a defendant, would want to enter into a plea arrangement. And so for those of you that don't know, a plea arrangement typically involves the litigant or the defendant pleading out to a lesser included offense or a related offense. Like, for example, in a DUI case, if it's your first offense, DWI, driving while under the influence or driving under the influence, we will, if we're the prosecutor, offer you a sweetheart deal like, okay, we'll let you plea out to a wet and reckless, which is not even a DUI. And after 3 years, if you stay clean and don't get any more DUIs, we'll allow you to expunge that, and we'll charge it as a misdemeanor so you can expunge it. And so I used to make a ton of money doing expungements, by the way. I charged like $600 for expungement, and I would do 3 or 4 of those sometimes a day, and that was good money. And basically it just involves doing a form and going down to the courthouse, and if you have to attend the hearing, that money includes that appearance. So it's a good deal for the defendant, and it was a good deal for me when I was going to court all the time. But obviously, when your back's all jacked up, getting in the car when your leg's on fire, it's not an easy thing. So back on topic here, a plea arrangement is typically entered into. And so most cases don't go to trial. The problem is, a little off topic, but not really, if you're a criminal defense attorney, once you sign on the dotted line, you're ethically required to represent your client, whether he pays you or not. And it's very difficult to get off the case. So most lawyers are like, unless you pay me 20, 30, 40 grand up front to handle the case all the way through, I'm not touching this case. And so what I would do is I would have 2 contracts. I would have a contract where you sign and you agree that if I'm not able to resolve the case by way of plea, that I'm off the case, unless you want me to represent you all the way through to trial. However, if I'm not able to resolve by a plea, then there's another fee that will be involved, and you agree that I'm out of the case, and you sign a form so I can present that to the court and say, look, we're not able to resolve the case. I have a contract with my client that it's up and to the time of plea, not trial, plea bargain. And so then the judge will let me out of the case because I have a contractual arrangement with my client. And so then I'm within the ethical guidelines. But most lawyers are money grubbers, from what I've heard from my other clients. And so they want that full amount up front, but they already know that 95% of the time they're going to settle it. But for that other 5%, I guess they just want to cover their bases. But I don't do that. I'll do 2 contracts. So but typically that plea bargain is going to give you some kind of probation, usually a fine, penalty assessment. I mean, they come up with all kinds of stuff that they want to hit you with, guys. And then, you have to pay it within a certain amount of time. And if you violate any of the terms or conditions of the plea, then the original charge you're guilty of. So it's not like they let you go to trial on the original charge. That's it. You violated it, and now you are guilty of the original charge. So that's always a tough one with somebody like Lane, where that the state might be out to get him. So they're going to try to violate him, many people would say, right? Like the cop may not like him, or this prosecutor may have an animus against him. And so, people will argue that, well, they're going to try to get me, and so I don't want to plea because, or like what they did with Carolina in Fort Worth, where she could have stayed 1 extra day in jail and gone back to her normal job of auditing or whatnot. But instead, I guess her lawyer pressured her, as based on my understanding, to take this plea deal, and got her out of jail a day early. And then I guess they put her on probation for like 1 or 2 years. And then the terms and conditions made it very difficult for her to go back to her regular career as being a full-time auditor. And that's what Carolina and Fort Worth does. She's into government accountability. So those plea bargains can really mess you up. And so that's where we're at in this case. Good seeing you, Chevy. Let me see here. Hey, Avilia Gill. It's been a while since I've seen you. I'm glad you're back. Oh, wow. And they said in Lane's case, the fine could be $150,000, Greg. That's insane. My gosh. I mean, where's Lane going to get 150 grand? I don't even think he monetizes his channel. I mean, I don't think that Lane was chasing money. I just think that he really believes in what he's doing. Another reason why I think he's really genuine. And that's another reason why I like him, because I don't like all the phony baloney crap on YouTube where everyone's trying to sell a t-shirt or something like that, chasing subscribers. So I thought that was really cool. Anyway, also always played some really cool music that I'd never heard before and got kind of crazy with his tie and all the crazy dancing and stuff. And I get a kick out of that because what I do, I always have to be on the up and up, wear the suit and tie, and I can't be out of character, right? Because I'm a lawyer, I'm an officer of the court. So it's harder for me because I like getting crazy because I still have that in my blood. I'm a crazy construction worker, Marine. I love all that stuff. So anyways, again, 95% of these cases are going to result in a plea arrangement. And in this case, Lane Myers went before this judge after the motion or petition to recuse the judge under Rule 10, the trial judge, was denied. Then part 2 came into play, and it was him arguing, strike that. It was the judge wanted to get on the record that Lane had knowingly and voluntarily entered into a plea arrangement. And then I covered some of the ways that plea deals work. Oftentimes, the judge has the final say in whether or not the plea arrangement is going to be honored. And oftentimes the judge won't tell you in advance what your fine is going to be, what your if you have to do jail time anyways, you might have to do. What usually happens is you enter into the plea and you throw yourself at the mercy of the court based upon the recommendations of the prosecutor. So the prosecutor could recommend, I recommend he wears an ankle bracelet. I recommend that he doesn't use YouTube anymore and he doesn't do jail time. And then you enter into that plea, and then the judge does your sentencing. And then the judge goes through, looks at your record, looks for prior included offenses, looks to see if there might be a multiplier. In other words, if you've got priors already, the judge could take that into consideration and do what they call like a multiplier. I don't know what they call it in Arizona. And so it can become a real problem. And so I'm looking at Lane, and my understanding is he's got a prior felony, but I don't know if it's violent or what it's for. I haven't gotten into that. So that could be problematic for someone like Lane, right? Give me a bunch of ones if you understand what I'm saying. Hey, SW Observer, good seeing you. My friend from Sweden. Yes, good day. Svenska, my friend. And Kevin Bernarski, good seeing you, bro. Glad you made it. So what we're going to do now is we're going to get back into listening to the judge and what is her name? The prosecutor, is it Stiles? I can't remember her name even. That's how wiped out I am today, guys. I mean, I'm literally fried. I've been up since 3 a.m. nonstop, depositions and working on reply briefs and stuff like that, just wiped out. So bear with me if I, lose my mind just for a minute. And we're going to get into what happened. Hey, BZ Watchdog. So yeah, in BZ Watchdog, we're going to nonviolent drug related, allegedly. Got it. Okay. So this is a public service is saying that his priors had to do with drug offenses. So they would be non-related probably, but I don't know how this would work in Arizona, to be honest. So I'm not licensed to practice law in Arizona. Again, everything that I'm telling you it's general legal principles as to the way I would perceive or handle a case if I was handling it in Texas or in California, the 2 states that I'm licensed in. And I am looking into getting waived into Arizona, New York, and DC as well, and maybe Washington State. But let me tell you something about being licensed in different states, guys. It's a nightmare. I've got to pay bar fees for each state. I've got to do continuing education of the bar for each state. and it starts taking up an enormous amount of your time. And unless my legal secretary is on top of it, I can get an administrative suspension. I could miss paying a fee, and then there'll be a thing on my online profile that says administrative suspension for 3 days because he failed to pay something. And then I'll have some idiot on YouTube say, "Oh, he was suspended. He lost his license. Oh, he's a criminal," because they don't know what they're talking about. So you got to be really careful when you get licensed in a bunch of states, guys. It gets out of control. But anyways, speaking of the devil, BZ Watchdog is here. So at 5:00, I'm going to go live again. I'm going to go after this show. Hopefully, I'll have some time after the show to rest a minute. And then I'm going to have Ryan, the angry Texan, who is a retired whistleblower cop, and BZ come on, and we're going to talk about some stuff that he's uncovered, some criminal activity, apparently even within the Texas Rangers, which blows me away because I always thought, Walker, Texas Ranger, we couldn't get much cooler than that, right? So we're gonna cover that, and I'm going to try to blast through this transcript of yours as quick as I can. This is a public service. And I hope you stick around. This is a public service because you know this case intimately. And if I ask questions, I do appreciate when you guys give me comments in the sidebar. And I do look over occasionally to make sure that I didn't miss something or get something wrong. I rely on you guys to be the trier of fact and to give me facts as I need them if I don't know them. So let's see here. And Rune Dragon says Texas just criminalized 37 million. They made marijuana illegal in Texas. I thought that it was legal if it was for medical purposes or something. Gosh, I need to do a show about that. That's crazy. That is nuts. I mean, look, I know so many, especially Marines, who are wiped out, who've been blown up by IEDs and stuff, and they smoke weed and take the tinctures and all that stuff. And I'd much rather see them on marijuana than drinking. I mean, alcohol absolutely destroys your body in comparison to marijuana. And most Marines I know get pretty damn violent when they've been drinking too much. And most Marines that I know that smoke weed get pretty damn sleepy. And I'd rather be around someone like that when I'm out in public, because when you're out with one of your brothers, you have to defend them. You're forced to. You don't have a choice. And so it definitely can save you a lot of barroom brawls and a lot of public fights when you're not dealing with an angry alcoholic drunk, especially a jarhead or some Navy corpsman. So anyways, guys, that's that. So let me see here. Now, Diesel says you can tell them on plea bargain that it is the judge does not accept the terms, that I'm revoking it. Well, that is true. That is true. And you're right. This is a public service. And man, I need guys like you to tell me that. It is, it's one of those things, especially for someone like me who's got a compulsive personality type. Man, you have that one glass of wine, and man, by the time you leave the restaurant, you've had 2 bottles, right? It's just not a good thing. And as you get older, your kidneys and liver are getting wiped out. And being a fitness guy, nobody wants to show up at the gym with a hangover, feeling like crap for 3 days while their body's recovering. And as you guys get older, it takes a lot longer to recover from those hangovers and all the damage. And alcohol does pierce the blood-brain barrier. And look, I'm not arguing in favor of doing any kind of drugs. What I'm saying is, if I had a choice of picking my poison, I would pick MJ over alcohol any day of the week. Give me a bunch of ones if you guys agree. But it's all pharmakia, it's all magic, it's all evil and condemned by the Bible. And so you got to be careful with that crap, guys. But I'm sorry to hear that, Kevin. Kevin says his brother passed away from alcohol. That's too bad, man. So by the way, we're going to get into it right now. Rest in peace, by the way, to your brother. We're going to get into it right now. And anybody who wants to throw me a super chat or a sticker or whatever, I'll always make sure to give you credit and put your comments and questions to the front of the line. Anybody who wants to purchase a copy of my ebook, it's $19.99. And this is one of the ways that I'm able to support my show and convince my wife that it's okay for me to spend so much time doing these. I have an ebook, My Journey to Becoming a Practicing Lawyer with No Law Degree or Undergrad. And I just take you on my journey at how I became a lawyer on the California State Bar Law Office Study Program. And I talk about the other states that offer similar programs If you're someone like Lane Myers or like a Chili DeCastro, like a legal scholar who's interested in becoming a lawyer without going to a traditional public school, because, you know, we don't want to get brainwashed by the blue-haired rainbow flag mafia at the public school system. Hey, Chevy, thank you. So everybody give me a big shout out for Chevy, one of my longtime supporters. He just threw me a $10 sticker super chat. Super cool dude. Make sure to like and subscribe to Chevy's channel. Check him out. Check out his videos. Super cool dude. Hey, Brandy, good seeing you. Outstanding. Yeah, so Brandy's always supporting me. Love Brandy. She's another member of Team MPE and Team DLZ over at Chili's channel. So I don't want to bore you guys too much. That is true. Justin Knighton says, I smell weed. That's the easiest way for the police to come up with probable cause to search your car and make an arrest and raise a bunch of money, put you in the torture cuffs, haul you off to the dungeon, and steal your money. Abso-freaking-lutely. I agree with that, buddy. And maybe we will make Brownie sing tonight, BZ. I don't know. So let's get into the actual meat of the subject. So this is the transcript that, now, do you guys like it? Okay, give me a bunch of ones if you want me to do it this way, and give me a bunch of twos if you prefer that I do it this way, where you can see the transcript. So when I do this, I cannot see your comments. I don't know what you're saying. I can't see your super chats or super stickers until I switch back over to look at the screen, because I'm going to be going to the actual YouTube video, the transcript that this is a public service uploaded from his video. I clicked on the transcript, and I'm going to be scrolling so you can read along with me. So give me a bunch of twos if you prefer me to be in this view mode, and give me a bunch of ones if you prefer that I be in this view mode. I actually strike that. A bunch of twos in this view mode. Oh God, man, what the hell? Okay, we're gonna do this over again. Give me a bunch of ones if you want me to be in this view mode, and give me a bunch of twos if you want me to be in this view mode for purposes of the transcript. Okay, it looks like twos. Looks like, hey, Dad. Dad, I think you're overruled. I think they want me to be with the big screen so they can read everything. All right. Okay, Josephine, I got you. Okay, right on, Dad. Yeah, sorry. Sometimes I kind of lose my mind. All right, so let's get into this, and I'm gonna do my God's honest best to get through this. But man, these hearings are long as hell. So, and by the way, guys, make sure to like and subscribe to Reluctant Prophet, and this is a public service, and make sure to donate money to their channels, because these guys are investing an enormous amount of time into Lane Myers' case, and I need you guys to give these guys credit where credit's due. And what better way is there than to compensate them for the time that they spend on this to bring you this entertainment? I mean, we don't have some big Fortune 500 company to support our channels. A lot of us have families. So this is just us donating our time and hoping that somebody out of the kindness of their heart will throw us $2 or $10 or whatever to show us recognition. It's not like we're making a bunch of money off YouTube videos. YouTube maybe pays you $2 for one of these videos. It's almost like not even worth monetizing. All right, so let's go ahead and get into the video. And I left off at about 1 hour and 21 minutes into it. And it's basically either the judge or the prosecutor reading off the terms and conditions of the proposed plea arrangement. Here we go. I'm not hearing anything yet. Hopefully you are. There we go.
I was wondering about, Rule 7.
Yeah, go ahead.
In Rule 7 to C, you can be released if there's a the rule reads, you can't be released if there's a reasonable probability of prison. Right. And so to me, this whole case is about videos on YouTube, right? So I'm already sitting in jail and the videos are still up. So I'm charged with a crime. I'm sitting in jail and the alleged crime is still happening. And then I'm going to plead guilty to a crime. sit in jail, convicted of a crime, and the crime's still happening, I feel like that makes a mockery of this whole court. In the sense that, you know, it must not be a crime, because I know in your 14 years as a prosecutor, you never agreed to a plea bargain where if you take this plea, you can keep committing the crime. That's never been a condition of the plea bargain, where you said, you know what, you can be charged for this crime, you can be convicted of this crime, but go ahead and keep committing it. Don't worry about it, it's no big deal.
I think I understand what you're saying. I think you can't keep committing the crime.
Well, the crime is the video that's on my YouTube channel.
Right.
And only I can take it down. So I'll be sitting in prison, and the video will still be up, and the crime will still be happening. That's doesn't comport with reality.
Well, they're charging with regard to specific dates, so that's one thing. All charges have a specific date and time, so.
One is the count one, well, they're calling it count 14, is a
Right.
period of time involving multiple videos. So I'm sitting in jail, and people are watching the videos as we speak.
Well, I think that if the state wanted to file another charge with today's date, perhaps they could do that, and that would be a whole nother legal argument. If you're asking me whether that could happen.
That's pretty interesting. Right off the bat, that's pretty interesting to me. I think Lane makes a valid argument that, I mean, and it sounds like the judge is even agreeing that, well, you know, or the prosecutor, is that the prosecutor or is that the judge? They're two females, so it's confusing to me. But somebody tell me in the sidebar who it is. But that makes perfectly good sense to me. I mean, Lane's concern, well, wait a minute, this is an ongoing crime, basically. And so if I enter into this plea today, couldn't she just turn around tomorrow and charge me with another crime since it's an ongoing crime? And so I think that is the judge. Okay, thank you. So this is a public service says that's the judge. So the judge is basically saying, well, yeah, I mean, hypothetically, while you're sitting here in jail languishing, she might be able to bring a new charge against you. However, these crimes are date specific. And Lane's going, well, exactly, they're date specific. And there's nothing in the plea agreement that says anything about the video being able to stay up or anything like that. But it does mention that the crime involves a YouTube video, apparently. So that's kind of problematic. And I could see why Lane would make those arguments. So kudos to Lane for having the foresight to understand the pitfalls of entering into a plea agreement. Let's keep going.
Well, no, I'm saying that, you know, what are we really doing here if the crime is the videos and they're not even worried about the videos coming down?
Well, sir, that's not a decision for me today.
Well, you can release me. That's what I mean.
Oh, under 7.2, so when there's a change in circumstances, and I think the fact that you have gone from what is considered a no bond because you have something on release and an allegation, that's my understanding why you were held no bond, is because there was an allegation of a new felony committed while on release. That's the basis of the no bond.
Presumption evident.
Right. So once, now, we don't have that pending, right? We don't have, if you enter the plea. Right, yeah, so we're on the same page, great. So if you entered the plea, we wouldn't have that pending anymore. In fact, we would have probation available circumstances. I think under those circumstances, it is the right thing to consider what release conditions pending sentencing. Now, this is how I typically do that, so you know. Somebody enters a plea, similar to this, where probation becomes available when it was not available as charged, okay? So at that point, then I would normally turn to the state and ask the state for their position with regard to release pending sentencing. If it's a victim case, I ask the victim their position pending sentencing. I then ask counsel, in this case you directly, your position with regard to release pending sentencing. After all of that, I would consider whether to release or keep you detained pending sentencing. Sentencing has to occur within 30 days. I can't tell you what I would rule. I can't tell you what the state or the victim would ask. I can just tell you that that's the procedure I would use with regard to release. If I released you, you'd be released. We'd have a sentencing within 30 days in front of Judge Metcalf. If I didn't release you, you'd have a sentencing 30 days.
So there's another little twist for you. The trial judge that Lane tried to get thrown off the case, who apparently doesn't like him that much, it looks like there's some bad blood between them, he would be the one actually hearing the sentencing. So that's kind of scary. What do you guys think? Give me a bunch of ones if you'd be terrified after all the infighting back and forth with the trial judge, that will be the same judge, the one who told you basically the reason you can't file motions and pleadings or respond in a timely fashion is because you elected to represent yourself. I mean, I would be terrified. I don't know about you guys, but I would already think, oh man, the fix is in. Well, let's keep going.
In front of Judge Metcalf. That's the procedure.
Right, and the procedure, I understand. We know the
Okay,
state.
just I wanted to make
I
sure.
know the state would say keep him in jail, but I feel like that's making a mockery of this whole thing. If I'm saying I'm willing to plead guilty and you release me today, I'll go home and stop the harm. And they're saying, you know what, no, just keep him in jail. I feel like that undermines their whole case, truly, because
There are different arguments on both sides, and I've seen both made.
I'm a very low risk score. I'm highly likely to get probation. None of these prior things, I don't even have them because they're dismissed. This whole count one case consolidated with the other.
That's kind of an argument for after, Mr. Myers, if you did enter the plea. I'm happy to hear your arguments with regard to release and the.
So I think you guys are kind of following this. So first he has to throw himself on his sword. And then after that, he throws himself at the mercy of the trial judge with respect to what the sentencing is going to be. It could be that he has to stay in jail. We don't know.
States as well
I
as.
know their position, and to me,
But that's something I have to consider only if you enter this plea. If you don't enter this plea, I'm not.
oh no, I'm not asking you to rule on that now. I'm just.
I want you to enter the plea
Oh, for sure.
because
I know.
I think it's the best for you, not for any other reason.
Well, I mean, it's when you take something like this, it's not just what's best for me. When they're hammering down your throat about the victim, I got to take into consideration, if I'm not a heartless bastard, the victim and this kind of thing. So if it's okay.
It's nice to hear.
My videos are causing, they're saying that even when I make a phone call from jail, she gets caused. So my videos are up, people can watch them, people can contact her, people can, quote unquote, allegedly harass her. While I sit in jail charged for the crime, other people are doing the exact same thing that I'm charged for every day. They're not charged. So what message does it truly send to victims everywhere, or to people that are watching the court right now, or 375 years of First Amendment, or I've never seen a case where somebody's been charged for criticizing the government in my life. I just read 14 hours a day of case law. I know Barbara LaWall would never charge these charges. I know that under Pima County since 1976, there's never been somebody charged for criticizing the government.
So, Mr. Myers, I just need to know today.
And of course, the judge or the prosecutor's counter to him would be, well, we're not charging you for First Amendment. We're charging you for harassing someone and using your YouTube channel as a basis to do that. But, if you look at Lane's, the entirety of this case, the nexus of how this all arose, his relationship with the original prosecutor, I believe his name was Walker, Texas Ranger. If you look at the totality of the circumstances, the nexus of this entire case arose from him booing at an anti-Second Amendment rally with a bunch of lefties, a bunch of commies in the audience applauding this mayor because she was in favor of, basically limiting people's ability to keep and bear arms to defend themselves. In all actuality, that's all it was. And so he said boo at the same time they were applauding, and then he gets criminally charged for that. So that the nexus of the whole case was him exercising his First Amendment right. And when I grew up, it was the reason you have the Second Amendment is to protect the First. Give me a bunch of ones if you agree with that. So I don't know. I just find it odd. It's a little disconcerting to me. Hopefully it's disconcerting to you as well. And again, that's why I try to get the younger crowd involved in my audience, because they've been brainwashed by the public school system. They don't even know that the real reason for the revolution was because the king tried to seize our powder houses, basically tried to disarm us, prevent us from rebelling against the state. So let's get back into it.
And I can give you another minute to check with
I'm
Mr.
just trying to
Resident.
figure this out because I don't want to make a mockery. the point of this is, we're making a mockery of this whole thing. If the victim is saying, your videos are harming me, but you can leave them up. We're making a mockery of this court every time I come to court. And so, if we want the circus to continue, the state has to work in this court. I don't. Okay, I only have to have one case here. The state brought this circus to town. The state wants this circus to be over in one end, but they're undermining their own argument by saying, well, we'll offer you probation and you can go back to the community, but you can't go back to the community yet.
So, Mr. Myers, the state makes plea decisions for a couple of reasons. And you're right, the benefit they get is they get a conviction. They don't have to take you to trial. That's their benefit. Your benefit would be less prison sentence than you would get if convicted at trial. Everybody's got a benefit and a loss when they do a plea agreement of some kind.
But
I am happy.
Doesn't the victim come into this? It's not just the state and the defendant.
The victim had the right to be consulted about the plea agreement, the right to make any objections that she wishes to make to the plea agreement if she had any, and the right to be present. She gets that right.
This is not a victim, quote unquote, victimless crime. So there's a victim in this case, right?
Right, and she has the right to be present, the right to know about the plea, and the right to object to it.
I'm just trying to understand. Okay, so the victim is being victimized, but they want to keep me in jail with the videos up and continue the victimization. That undermines the whole, I read a lot of case law over the weekend, and I haven't found a single case of a public employee being able to charge somebody with harassment.
And you're welcome to take it to trial, Mr. Myers, if you think you have a valid case. By all means, it's very important that you exercise your constitutional right to a trial if you think that's what's best for you, or you think that that's what's right.
To me, reading the rule, the state we can stipulate to my release.
Well, the state doesn't have to, though.
I'm not saying they do. I've already talked to them about it.
Yeah.
So I just don't really know, vastly, because
I don't think you should enter this plea based on release or non-release.
Well, that's the only reason I would do it, because, I'm only getting...
Well, boom, there you go. So already, if I'm the judge, I'm thinking, oh boy, this is going to go sideways real quick. The only reason this guy's doing this is because he wants to get released from jail. So, and obviously that's a pretty damn good reason. He's already been allegedly assaulted by one of the correctional officers. I think that he's got a lot of reasons to not want to be there, guys. And just really quickly, let me just look over at your comments. I want to make sure I don't miss anything. Hey, good seeing you, Chili. So, Chili, it looks like, since Lane's still in there, I know you want to interview him. So I'm going to reach out to RP or This Is a Public Service and see if there's a way we can set that up for you as well. And I know that Lane had some legal documents that he wanted me to at least look at. I can't give many legal opinions because I'm not an Arizona attorney, but definitely been interested in getting Lane back on and letting him, at least have someone to talk to. And it's Chili, as you know, being locked up, it's just so terrible. Just to know that you have a friend and someone who cares about you is a really, really big deal. Even if it's not somebody you know that well. You know what I mean, right, bro? It's just having that contact with someone from the outside world. It means all the difference in the world to someone. And so, that's what I'm all about, guys. Oh, gosh. Chili says they serve So Chili's actually suing over that case where he was falsely arrested. He's going after the judge and the prosecutor. So I wish you the best, brother. So give me a bunch of ones for Chili DeCastro for showing up. And then now, This Is a Public Service says, send me an email. He'll gladly do the interview. Okay, so it's going to be two. It's going to be Chili, and it's also going to be me. Two separate interviews. That's two separate calls. We're both willing to cover the cost of the call for both the different interviews. And I'll put Chili in touch with you. If it's okay that I give him your contact information. I don't have your email, but I do have another way to contact you. And I'll do that. And, Chili's got a pretty big audience, over 600,000 people. And I've told you guys this a million times, and I'm going to say it again. If you guys want to make a difference, I think recall elections is a great way to go. I think 600,000 subscribers with Chili, 60,000 over at Reluctant Prophet and Counting. I don't know how many you've got. We got John Felix. I mean, I would say there's over 1 million subscribers, and probably 50 to 100,000 of them are in Arizona. If you guys want to make a difference, I've told you this before, this is my opinion, recall elections and start getting involved in the local government, guys. Run for school board, run for sheriff. If you really want to make change, if you really want to honor your oath to uphold, protect, and defend the Constitution, put people in office who put their oath before their publicly taxpayer-funded pensions, paycheck, and promotions. Give me a bunch of ones if you agree with that. All right, so let's get back into let's put your money where your mouth is, like I've been trying to do. I've been burning the candle at both ends, trying to use my law practice to support my family, and at the same token, still come on and try to do these shows for you guys. Now, oh, thanks. So Chili says there are things that Michael did for me when I was in jail that I will not be able to reveal until he retires from the legal profession. Well, that's very kind of you to say, Chili. I just, all I'm trying to do is do my best based upon what I think God wants me to do. I believe that I have the Holy Spirit guiding me in these things that I do in my life. Whether you're religious or not, I just want you to know that I have a higher power that I serve. I don't just serve myself. I always believe you need to serve a higher power. There's more at stake in this universe than just you guys. We're all herding animals. We're all put here for a purpose. And sometimes things happen, and we need to support and rally around causes and people that we care about. All right, let's get back into the transcript.
Trial's July 22nd. I'm going to go sit back at the jail for 30 days, give up all my rights to an appeal, stop litigating the case, not get my depositions, not force the victim to come under the scrutiny of the witness stand, not catch the detective under, he perjured himself at the grand jury. I'm giving up a lot of strong leverage too if I take this. And if it's just, well, you'll get less charges and still go to prison, well, that doesn't benefit me because then I don't have the appeals. So I'm giving up. I would rather go to prison for more time and have all my appeals, because all my appeals say that I'm not guilty. All the case law says I'm not guilty. So if we were just deciding this on case law, this would already be dismissed.
And by the way, I do believe, remember, my background is in appellate law. I was an extern for the California Court of Appeal at the Ronald Reagan Building when I was coming up as a lawyer. And I believe that harassment statute is unenforceable as a matter of law. And I do believe if it was in federal court or California or Texas, that I would be able to get that case reversed on appeal. That is my God's honest opinion. Oh my gosh, thanks, Chili. So Chili just threw me a, who's going to match me? Oh, thanks. So Chili's playing my game. So I always do this, guys. I'll throw up whatever I can afford at the time, and I'll say, whoever doesn't match me is gay or something, right? For all you old codgers, but I spell it G-H-E-Y. So for all you gay guys, it's just a joke. Don't take it personal. I don't really care. It's just for fun, okay? Like in high school, little games that we would play. And I do stuff like that to try to help your channels because I want to support you guys. Oh my gosh. Thank you, Chevy. Chevy just threw me $20, guys. And again, look, even if it's $1, that's all that matters to me. Just, that you show your support. It's pretty awesome. And I do the same thing with This Is a Public Service and Reluctant Prophet. That was very kind of you, Chevy. Both you guys are awesome, man. All right, so let's get. By the way, I heard from Life Under the Microscope, Chili, that you had like 2,000 viewers in one of your live streams the other night. He always reaches out to me and lets me know what's going on. As you guys know, so really quickly, guys, I don't want to digress too far away, but so I homeschool my kids, all right? And it's very important to me that my son stays active in judo, in martial arts, Muay Thai. And so I'm not able to always come on as a guest to your live streams. So Life Under the Microscope and guys like Kinetic Customs sort of keep me in touch with what's going on your channels. But I am going to come by and visit you guys and say hi, Chili, and everybody else. I try to make my rounds. I was in a depot today, and I came on This Is a Public Service to throw them a couple bucks and say hi. Holy crap. Look at all this stuff. Okay, well, give me a shout out to Brandon Jennings. Everybody like and subscribe to Brandon Jennings for supporting Team MPE. Let's OTVO, thank you also, brother. Let's OTVO. Hopefully I'm going to cover your incident tonight with BZ Watchdog, you and Brick's incident. You guys are super awesome, man. All you guys rock. So thank you for supporting my channel, all you guys. You guys are amazing. And thank you also, Brandy, as well, for trying to help me sell my book. Hey, who knows? If I can sell enough copies of my book, maybe I can do this full time. But for now, this is how we got to do it. All right, let's get back into the video. I'm touched, man. You guys are so cool. I can't believe it.
But you can't get into the facts, before trial.
Right, and you alone have to make this decision as to what's best for you, whether entering a plea or going to trial is. And you're right, you give up rights, the state gives up things as well at a trial, and you both get things out of plea. That's the way, to me, a plea agreement is like any other contract you enter.
Yeah.
It may sound silly to compare it to a contract to build a house or something, but in reality, or to buy a car, in reality, in some ways, it is the same. You get a benefit, the car you're buying. The seller gets a benefit, the cash for the car. You do it for those reasons. The seller loses something, the car. You lose something, cash. So it makes it very simplistic. But a plea agreement.
And just to give you a little information, so contract law, that's called a bargain for exchange. Both people give up something, right? That's called consideration, just so you know. Promise for a promise, promising to do or not do something. In this case, I promise not to give you as harsh of a sentence, and you promise not to engage in the same behavior. So there's a bunch of different ways you can enter into a contract. It can be with money, it can be with a promise, but you've got to take some kind of an action. If it's just with a promise, or not doing something could be considered consideration, for example. Let's keep going.
It really should have a benefit to both, and there's something you both give up.
That's right.
This, on paper alone, shows a benefit to the state, to me, and a benefit to you. That's just paper alone. That's not the basis behind the paper, like the arguments, legal arguments that you believe you have, Mr. Myers, and whether you think you can win this case either in trial or on appeal. That's a separate issue, but it is important that you consider the fact that you could get convicted in a lot more prison time. And Ms. Stiles, if I'm correct, if he's convicted at trial, there is some mandatory.
By the way, thank you, Gloria. Thank you.
Yes, of everything as charged.
So if he has prior convictions, they're old, but they would make the prison mandatory even if he's just convicted in one felony at trial. And then because of the separate dates, he faces the possibility of stacking, and that may be then treated as a category 1 repetitive offender. And then on the second case,
okay, just so you understand, so in the prosecutor's business, because I also worked for the prosecutor's office for the city of Los Angeles, you can have concurrent sentences, you can have stacking of sentences. So there's all these different ways that the judge may decide to concurrent, or anyways, we'll get into this in another show. But just because he's entering into this plea deal doesn't mean the trial judge still won't throw the book at him and give him time served. So it's pretty scary to enter into a plea deal when you feel that the trial judge is biased against you and you just tried to get that trial judge thrown off the case. Judges are people too, guys. And I'm not saying that this judge is or isn't biased, because I'm not the lawyer on the case. And as an officer of the court, I'm not going to pass judgment on him. I'll let you guys and Lane Myers make up that decision. I can say that based upon the argument that Lane made, I feel that he had a powerful argument that the judge saying, by you electing to represent yourself, in effect, you've disentitled yourself from being able to timely file and receive pleadings and paperwork in order to prosecute your defense. That's just from my personal opinion, if this was in California or Texas. So because I'm not licensed to practice law in Arizona and I am an officer of the court, unfortunately, I'm not going to put myself in the precarious position of ending up like Lane Myers, especially after I saw what happened to him.
we also have the on-release allegation, which would then imprison. So yes, well, no, it adds 2 years.
And that 2 years is flat, isn't it?
So, and that's,
Yeah, that's my, am I right, Mr. Resnick, that 2 years is flat?
I'm aware of all that. I just don't see the benefit to the state. curious because I haven't seen my parents in 5 years, and they have been planning to come to Tucson next week for 8 months anyways, which the state is aware of because they listen on my calls and read on my messages. So, I mean, the only...
Well, they'll be here then either way.
Beware.
Whether you go to trial in July or whether...
No, I mean, they're coming to visit next week. They live in Michigan.
But I thought you said for 8 months.
No, we've been planning this
Oh.
for 8 months.
I apologize.
This is something that was in the works for 8 months, and now suddenly I'm in jail. They're driving across the country to visit my sister. They're 70 years old. You know, the state is going to argue against me being released today if I enter this plea. So to me, the benefit would be that I get to see my parents who I haven't seen in 3 years. You know, I get to go home and take the videos down and direct the attention. You know, then the videos will be, oh, look, the judge did the right thing, or the court did the right thing, and they let this guy out of the gulag because he should have never been there. But it doesn't seem like the state, I feel like the state is disingenuous.
Your Honor,
I
think Mr. Myers is hoping that I'm gonna change my mind and agree to his release. I can tell you that will not happen so he can keep talking about it and throwing that out there. It will not change. And I stressed that to him. My belief is that he needs to be in custody until sentencing. He had his arraignment on the first case, and that very weekend, he went and committed new felony offenses against his victim.
I would say it right at the outset. Objection assumes facts, not an evidence. This has not been adjudicated. Allegedly, the defendant committed a felony. I have a lot of problems with the way it's being framed. The framing here doesn't look good. Oh my gosh, thank you so much, Clay. Clay Foundations just threw me a super sticker. Hold on, guys. Make sure again to like and subscribe to Clay. And it almost looks like Rick Jonesy, if I'm not mistaken. But man, you guys are awesome. Hey, I'm going to have a nice steak dinner tonight, man. Maybe I'll be like that lawyer who has the storage facility that talks about how he likes to get a steak and a nice glass of wine after he makes $20 doing a family law case. Oh, maybe I'll make a big payday. Right. All right. All right. Let's get back into it. So really quick. Dude, it is Brick. Right on. Hell yeah. Good seeing you, Brick, man. You know, you're my homeboy for life, man. I really appreciate it that you were there to support Chili when so few people were, even though he was innocent. And that really irked me big time, the way that so many people assume that just because you're arrested, just because you're jailed, that means you're guilty. That is very communist Chinese, Mao Zedong, Joe Stalin-like. It goes against everything our founding fathers stood for. All right, so you were definitely a great guy, man, a good man. Let's get back into it.
So I understand it's alleged. I understand it's the state's argument.
And so, you know, I have concerns if he is not being supervised by probation. We made it probation available, but probation comes with a lot more conditions of release and a lot more monitoring than does pretrial services. And pretrial services, him being out before was not enough to stop him from doing this. And so if he's giving this speech right now, hoping that I'm going to change my position on that, I can tell you it's not going to happen. And if he would like to go to trial, we are ready and, you know, to go to trial. So he can make his choice. So if he wants the plea, it's available to him today. If he doesn't want the plea, we're able to go to trial.
Yeah, I don't think I was trying to get.
Can you do it? Hold on 1 second, Mr. Mayor. Can you do a Donald record today? About that information? It's okay if you can't. I just wanted
Yes, I'm starting to write.
So a Donald record sounds like some kind of a case that they'll call it, you know, a Wheeler motion or something. So a Walker hearing or whatever. So they'll call hearings and motions and proceedings by a name of a case that came down, and that somebody wants to Google it and throw it in the sidebar for me. What is a Donald record? It sounds like some kind of a record when they entered into the plea, so the court, or if he gets violated again, can go back and look at that, and they call it, it sounds like it's called the Donald record. I don't know. If somebody knows, tell me what it is and put it in the sidebar. I'm not looking right now at the sidebar. I'm scrolling to make sure you guys can watch, because the audio, unfortunately, under the 122H rule, apparently has been disallowed because the husband of the victim, who's also a prosecutor, the alleged victim, the complainant, has a petition to disallow people from audio recording in court because somehow that's going to interfere with the proceeding. I see absolutely zero basis for that. I think it's absurd. I think it's definitely overreach and definitely goes far beyond the separation of powers doctrine. And I also, even though I'm not a resident of Arizona, did voice my concerns in that petition online. Let's keep going.
Get out and, like here.
I know that. I know it's a lot of math.
What is that?
Okay, so the Donald record, that's a case, and it basically says that,
Oh, there it is.
so if you accept a plea, I have to find that you knowingly, intelligently, and voluntarily. If you reject a plea, I need to know that you knowingly, intelligently, and voluntarily reject.
Yeah, we do the same thing in California. We have a different name for it, but it's the same thing.
You can't knowingly or intelligently reject something you don't know what you face, for example. So if you have no idea what you face being convicted at trial, how are you knowingly rejecting the plea agreement? So I need to know what
I see.
you're facing at trial, and I've not done the math, so I asked Ms. Stiles if she had, what you're facing at trial, so I can ask you to compare what you're facing at trial with this, and if you want to reject the plea, again, no problem. I'm just knowingly, intelligently, and voluntarily getting on the record that that's how you're rejecting it. Does that make sense, Mr.
Yeah, yes, and I don't think I'm not trying to get her to change her mind, because it's up to the court. It's not up to her.
Correct.
To release me.
And you know she's gonna argue that.
Of course, I already know that. That's why I don't even know why she's granting it. But the point is that I gotta consider the rest of my life and the felony convictions. I own businesses, employment, things like that, versus, sitting in jail a little bit. I'm gonna already be sitting in jail another 30 days if you don't release me, which I'm sure doesn't scope, whatever the state says. And then I could have just sat in jail a little bit longer and been found not guilty on all this and had a giant lawsuit against the city of Tucson, the police department, and all that. And, giving up all my appeals, I just don't understand how this plea bargain benefits the victim.
Well, it doesn't have to benefit the victim.
Well, the victim's not even being harmed.
But the victim, so the victim has to be aware of the plea agreement and has the right to object to the plea agreement. The state can offer a plea agreement regardless of how the victim feels about it. So if the victim doesn't like the plea agreement, and I've had victims not like a plea agreement both ways. It's too harsh, it's too easy. I've had both from victims. So the victim has that right. The victim doesn't control whether the plea offer is made. That's actually controlled by the state.
You have one more?
Sure. That makes sense. Sure. My understanding, just so you know, Mr. Risky, because our mute buttons aren't working real well, so you might want to move the microphone if you need me to say anything.
Right, the buttons aren't working that well. The audio recordings all suck when they're done by the court, but yet it's in the public interest to disallow parties and observers from audio recording in court. I mean, give me a break, guys. It's just, we'll talk about overreach. I'm not buying it, man. Hey, F, good seeing you, man. I just popped over since it looks like they're doing a sidebar or something. Looking over at the comments. Hey, Naira and Noel. Good seeing you, man. Super cool. Huge overreach. Absolutely. Huge overreach, in my opinion. Big F. E-Lion. I like that. E-Lion. Maybe I should change my name like Snoop Dogg changed his name to Snoop Lion. Maybe I should become Mike Lion. Well, it's not live now. It was live a couple days ago, Billy. This is the plea, the alleged plea. Remember when I said it sounds like Lane's entering into a plea? And the audio was so terrible, right? Because nobody had audio except the court, and it was just so shitty that I presumed that he'd entered into the plea because we didn't hear anything. Well, somehow we were able to get this audio recording from this as a public service. And this is what we got.
Do you want this on the record?
Man alive, this is a long one. This is a public service. I got nothing but love for you, dude. You covering this thing is amazing. This is hours and hours and hours and hours. Insane. That is true. Very difficult to sue a prosecutor, almost impossible. You've really got to have some serious facts, evidence. It is almost impossible. Yep. Prosecutorial immunity, big deal. Hey, Jody, good seeing you, ma'am. Jody Shiloh.
Everybody needs to stand and stretch your vote while we get a minutes.
So here, I'm going to try to speed this up a little bit just because I've got this other show coming up. So 149 is when this starts again, somewhere right around there.
All right, Connor.
Yeah, oh, yeah, sorry, I just got the email right, so now my attention's on you.
Good?
Yes.
All right.
So just so we're formal, we're going back on the record, so, and I didn't get a chance to your advisory council, what would you like to do at this time? You wanna do the plea? Okay, if you wanna do the plea, I need you to sign it. Does he have an original one?
This is the one that doesn't have the, I've got
Oh, you've got it, okay,
I just need to sign this here.
okay, and then,
Your Honor, the victim does want to be heard at some point.
do you wanna be heard before, ma'am, or after?
Do you want to be heard before she goes through all of it, or do you want to be heard before she?
If you have any objection, I'd rather hear you before, but if it's something else, then I can hear you after, whatever's good.
So typically in California, we would call this the victim witness impact statement. And this gives the alleged victim an opportunity to throw the book at the alleged defendant. And then the trial judge would take all that into consideration after the plea has been entered into to throw the book or not at the actual defendant. So obviously this is kind of scary. And I can already tell we're going to run over time, guys, because I'm going to shut this down around 4:50 so I can make a head and water call to start the next video, which is going to be BZ Watchdog, which I've been promising him for weeks. So I can't flake out on him. So it looks like this is going to go into a part 4 for you guys to come and join me to finish it. But at least we'll get to hear what the alleged victim has to say as well, because it looks like this is going to go on for a lot longer, guys. Woo, man alive. But here we go.
It's not really an objection, more consideration.
Okay. Thanks. more comfortable if we heard her from her first?
But no one's recording it.
Whatever makes her feel best.
So you want to go, let me know your concerns or what you would like me to consider here. And it's Ms. Walker, correct?
Yes.
Okay.
Yes. Your Honor, thank you for the opportunity.
Okay, so just so you guys understand, so the victim, her name is, I guess, Walker, and she's actually a lawyer herself, and she works for a public university. I believe she's a law professor, if I'm not mistaken. And her husband is a city attorney prosecutor. And so he had brought charges against Lane Myers for booing at a public meeting about the Second Amendment. That was an anti-Second Amendment public meeting. And Lane won that case, and I guess he went to the university or called Miss Walker because he wanted to get an interview, and then YouTubed about her not allowing him to interview him. It kind of blew up where he gave out the public website information about her, about his unhappiness with her on his YouTube channel. And I'm paraphrasing. You can put it in the sidebar if I missed anything. And then ultimately she came after him and tried to file, I believe, a civil injunction against Lane, and Lane won that injunction. And then ultimately the husband of this woman, who's also a prosecutor, apparently was somehow or another able to forward felony charges over to, I guess, somebody that he knows at the felony county prosecutor's office. And that's how it ended up here. So I guess it pays to have a husband who's a prosecutor, right? I mean, to me, it does have the appearance of impropriety and abuse of power. If that's what I would be arguing on appeal as well. And I would probably want to lodge a complaint with the state bar if this was my client, because it just doesn't it doesn't seem right. It's something, it just doesn't pass the smell test to me. And of course, the same husband actually filed a petition to disentitle people from recording in court. It just doesn't look good, guys. It doesn't look good. Tell me what you guys think in the comments. To me, it just does not look good. It has a bad look, and it makes me think recall elections and bar complaints and commission on judicial performance complaints. It just doesn't pass the smell test. And that's me as a private person observing this as if I was a private person in Arizona. But if I was in California or Texas, these are the maneuvers and steps that I would be taking to try and somehow get some sort of justice in this case. All right, let's keep going.
While I understand that the specific sentencing details, including any prison time and probation conditions, will be determined at a later stage, I feel compelled to make my position now, as these conditions are critical to my standard of the proposed plea. I appreciate that Mr. Myers appears prepared to plead guilty to the many crimes he has committed against me. In doing so, he is acknowledging that his conduct is not protected speech. It was a sustained and calculated pattern of stalking and harassment that caused serious harm. These were not isolated or impulsive actions. They were intentional, repeated, and profoundly damaging. However, while I do support this plea agreement, I have serious reservations. Mr. Myers has shown time and again that he's unwilling to follow court orders. Based on his behavior, I do not believe that he's capable of complying with probation without strict and ongoing oversight, along with serious consequences if those terms are violated. Anything Mr. Myers enters should ultimately be accompanied by a period of incarceration, which I understand will be determined by the METCAP, as well as strong enforceable probation conditions, which is conditions that are specifically designed to protect me, my family, and the community. These measures are necessary not only to reflect the seriousness of Mr. Myers' crimes, but to ensure that I and those close to me can record in safety. When the court considers sentencing, I will be prepared to request conditions that provide meaningful protection. In the meantime, I respectfully ask the court to take this into account as the case proceeds. Thank you. Thank you very much.
So that was the
Marcia,
victim.
should I go through with the plea? If so, I just need the signed copy and I can leave.
So that was the victim, the wife of the prosecutor that Lane Myers originally beat in court, who's also the same guy who's trying to disentitle the people of the state of Arizona from being able to audio record in court under the provisions of 122H, as it was originally envisioned by the Supreme Court of the state of Arizona. And so that's the wife of that same prosecutor who's filed that petition, who lost a case against Lane Myers, who brought a case against Lane Myers originally for booing at a public meeting at the same time other people were applauding.
If you're ready, if you sign the plea, then I'll make sure Ms. Stiles signs the plea, because my understanding is she has not either, and I need her signature as well. And then I would go through the questions with you.
All right, so here's what we're going to do, guys. We're going to stop at 153. We're going to stop at 153 because obviously I want to look at if anybody has any questions for me in the sidebar. I start another show in 10 minutes, not on this particular show that we're doing. I've got to log out, log back in to start my other show where BZ Watchdog, he is a citizen journalist, and he is one of the best public records request guys I've ever met in my life. Whenever my law firm needs somebody to do public records requests, this is the guy that we look to. He's basically like a private investigator, but more than that, he's also an inactive United States Marine like me, so we're buddies. And I promised him that I would cover some stuff that he wants to expose on another show at 5 o'clock after this. So it looks like we're going to do a part 4, but really quickly, privates. Let me go over here to the sidebar. Life under the microscope. Good seeing you, brother. Hopefully I'll see you today for the BZ Watchdog show. And Nair Amal that says, good, he recuses himself because he's afraid of a bar complaint. Bye. And then, yeah, that's, I don't know if you're referring to me or the husband, but probably the husband. I'll be honest with you guys. I'm going to tell you right now, if I was a prosecutor and my wife was a victim in a case where I had already lost a case against the defendant, I would step as far away from that case as possible, because it would have the appearance of impropriety that I was trying to retaliate against someone that I lost against. And I would make sure that I had nothing to do with that file. I wouldn't be actively engaging in the case. I wouldn't be actively trying to file a petition to disentitle that same person that I'd already lost a case against, who happened to have also contacted my wife, who happens to also be a public official, who works for a university that's tax funded. It just doesn't look good, guys. I would never touch that case with a 10-foot pole. So I'm just telling you, if that's what you're referencing about recusing yourself from the case, I mean, it doesn't take somebody with a law degree to know that it has a bad look. If I was the attorney general, and I would be opening an investigation, because it just has a very bad look, a very bad look. It reminds me of, you guys ever watch the Dukes of Hazzard? Well, or Cool Hand Luke? That's what it reminds me of. It has that same feeling. It just has an air of impropriety about it that I just do not like. It just looks really bad. So with respect to this particular case, good seeing you, Dad. Love you, Dad. Thank you for joining me, Chili de Castro. Thank you, Mias Taro. And you could as her husband and not as her attorney, though. I certainly could, Mias, but I couldn't use my prosecutorial power to try and pass the torch of prosecutorial power to another prosecutor. I would step away from that, and I would allow another attorney in my office to handle that case. I mean, from taking ethics as part of becoming an attorney, there are a lot of general and specific California bar guidelines that I can see raising red flags right now in my mind. And so I just think it has a very bad look, especially if I was trying to disentitle people from recording in court and filing a petition with the Supreme Court, using my power as a prosecutor, trying to get people to endorse me from the state bar, because it has the appearance now the commissioners, because they all know that this is because of Lane. Everybody knows that this petition is being filed because of Lane Myers. So now we've got court commissioners, judges, apparently, the State Bar of Arizona endorsing this petition, and they all know that it's because of Lane. They all know it. They know it. And so it looks like the fix is in for Lane. It really does. And that's why I had encouraged Lane to try to do a federal removal, because I do believe if this was in California or Texas, that this is absolutely a 14th Amendment denial of procedural due process. It almost looks like a Monell claim, where we have a prosecutor or a prosecutorial agency exceeding and going beyond the scope of their powers and using their powers in an unjust manner. And so, I don't practice law in Arizona. I'm not going to pass judgment until I know more facts, but it has the appearance of impropriety. And I've spoken to many retired judges as well as prosecutors who agree with me. And that's why I'm bold enough to make this statement. And I hope to God that somebody at the prosecutor's office or at the Supreme Court of Arizona recognizes what's happening here. It just does not look fair to me. And I'm hoping that you guys who are in Arizona, who have the ability to make positive change, can petition your government for redress or get active, run for mayor, run for commissioner, do the things that you need to do to support, protect, and defend the Constitution as our founding fathers had envisaged. With that being said, guys, I've only got a couple of minutes before the next show. I got to make a quick head and water call. Thank you for the super chats. Thank you for supporting Team MPE and my family as well, because obviously I'm giving up a lot of time with my kids, homeschooling them and stuff like that to do these shows. So any little thing you do to support me, it really means a lot. Make sure to like and subscribe. Make sure to save, because we never know when the thought police are going to take down this channel. And come and join me in about 5 minutes for the next show that's going to be coming with BZ Watchdog and the Angry Texan. Semper Fi, do or die. God bless you guys.